Greetings and welcome to Law of Evidence, Knowledge of Facts from American Jurisprudence. And if everyone's here, we'll get right started with the program here. Starting with Chapter 9 on knowledge from the American Jurisprudence on evidence. And here we're going to start with Section 282, which is generally the knowledge of facts. Let's get down to it. Just a moment here. Jeez. All right, I hope we're all there. If we could get a heads up in the chat there to make sure that everything is streaming, that'd be good. Looks like it's all going good on this end here. All right, there we go. Okay, let's start. Generally, knowledge of facts. A knowledge of facts may be presumed or inferred under the circumstances of case, at least insofar as there is a duty to know such facts. Duty to know. One is presumed to know the truth in regard to facts within his own special means of knowledge. What a reasonable person ought to know from facts brought to his attention, and where there is a duty of inquiry, whatever proper inquiry would disclose. So if you have a duty of inquiry, a duty to know, you must ask certain questions. Proper inquiry would disclose such facts. The actual existence of a condition for a considerable period of time is presumptive evidence of notice or knowledge of its existence. So, the actual existence of a condition for a considerable period of time is presumptive evidence of notice or knowledge of its existence. You've been sitting in a cold room for 3 hours. You would have to have some kind of knowledge that the room is cold. Every person is presumed to know his or her own signature and the contents of contracts to which he becomes party. Ooh, now this is an important one here. Every person is presumed to know his or her own signature. Now, when they say his or her, we're speaking more so about a natural person here, I believe. And the contents of contracts. How many people are really know all the contents of contracts which they've become party? But before we go any further, just to remind everyone that this broadcast is strictly for the entertainment and educational purposes of the YouTube channel, and this broadcast only not to be used, misconstrued, or mispurposed for any kind of legal, lawful, personal, private, business, tax, financial, or otherwise, so please don't do this at home. Let's continue. Even in criminal prosecutions, even though there is no general presumption of the knowledge of facts, the law raises a presumption in some cases that the defendant had knowledge of the existence of the facts involved in the case. There's no general presumption of the knowledge of facts. The law raises a presumption in some cases, though, that the defendant had knowledge of the existence of facts involved in the case. The presumption of knowledge of facts, which inquiry would disclose, may be rebutted by showing the existence of other and attendant circumstances of a nature to allay suspicion and to lead to the belief that inquiry was unnecessary. This is very tricky here. Something you got to really be aware of when dealing with esquires. The presumption of knowledge of facts, which inquiry would disclose, may be rebutted by showing the existence of other and attendant circumstances of a nature to allay suspicion and to lead to the belief belief, not facts. We went from knowledge of facts to leading to a belief that the inquiry was unnecessary. So, existence of other and attendant circumstances of a nature to allay suspicion. It's all it takes to lead to the belief instead of a presumption of knowledge of facts, which inquiry would disclose. So this is one way of rebutting an inquiry into facts, right? That such knowledge can only be obtained by the inquiry. However, if there's attendant circumstances of a nature to allay suspicion and lead to the belief that the inquiry is necessary, then there's no longer, this won't stand here as far as the inquiry to disclose knowledge of facts. Furthermore, the law does not presume that a fact, once known, is never forgotten. Wow. This is another important presumption. The law does not presume that a fact, once known, is never forgotten. Memory does not always serve. All right, so let's see here. Local authorities are presumed. Local authorities are presumed to have knowledge of local conditions. Presumed. But would the inquiry lead to a different knowledge of facts? Or would their attendant circumstances of that certain nature here to allay suspicion because they have that presumption of knowledge? As you see here, one who has been ousted from possession of his real estate by an open, visible, and exclusive possession in another, which has continued uninterruptedly for the limitation period, will be presumed to have had knowledge of it. This, I think, is referring to adverse possession. The owner of property is presumed to know the business conducted thereon. Corporate officials are presumed to have knowledge of the contents of instruments and documents shown to be in their possession. Wow. The law assumes that one who has knowledge of a danger has knowledge of the injurious results naturally and proximately flowing from the danger. So one who has knowledge of a danger also has knowledge of the injurious results naturally and proximately flowing from the danger. Wow. The condition of a city prison for several months is presumed to be within the knowledge of the authorities. However, a tenant in an apartment house is not, by reason of her occupancy of the premises for a year prior to a fire in it, conclusively presumed to have had knowledge that there were no fire escapes provided, as required by law, and to have waived their erection. As to actual and constructive notice of a defect in premises, see the AmJur on premises and liability. All right, and we have a few more cases here. And we're on to section 283, knowledge of law. As we've often heard, ignorance of the law is inexcusable. So we must all have some knowledge of the law to one degree or another. All right, and before we do that, let's jump over here to the chat and see if anyone is piped up in here. Please hit the like if you just joined the stream. Other than that, let's get right back down to it. A rule frequently stated is that everyone is presumed to know the law. And this rule has been deemed applicable whether the law involved is state or federal. That's it. We've heard this many, many times. Everyone is presumed to know the law. This presumption is merely a restatement of the substantive rule that ignorance of the law is not a defense or excuses no one, or is wholly irrelevant. While ignorance of the law excuses no one from the legal consequences of his wrongful or negligent acts, nor will it relieve him from the legal effect of his contract obligations in cases where ignorance of the law is a defense, such as where a statute includes a specific intent requirement, the rule has no application. So what they're getting at here is that if you're ignorant of a specific intent requirement within a statute, then you can't be held responsible for having knowledge of that. So ignorance of that specific intent requirement of the statute is a defense. Parties to business or commercial transactions are conclusively presumed to know the relevant law. Conclusively presumed here. So if it was the finder of fact being a jury, that they would have to be instructed that these presumptions are to be conclusively accepted. They're not going to be able to judge whether they want to permit the presumption to be admitted as evidence as fact, but is conclusively presumed to know the relevant law. So parties to business or commercial transactions are conclusively presumed to know the relevant law. It has been held that everyone is presumed to know the limitations fixed by law upon powers of corporations. The effect of recording as constructive notice of title. The power and authority of federal agencies with which he deals. Laws establishing legal relations, such as joint tenancy. The law of descent and wills. That the use of certain dangerous devices or products is subject to regulation, and the validity or invalidity of a divorce decree to which he is a party. So let's see here. These are a nice little laundry list here of parties to business or commercial transactions are conclusively presumed to know the relevant law. So if you're a party to a commercial transaction or business, then there is a conclusive presumption that you have knowledge of the facts of the law that apply. It has been held that everyone is presumed to know the limitations fixed by law upon powers of corporations, the limits upon powers, the effect of recording. So it has been held that everyone is presumed to know the effect of recording as constructive notice of title. So by recording the title, then it's constructive in the sense that it makes it now marketable, that other people will be able to recognize that title, that ownership. The power and authority of federal agencies with which he deals. So if you're dealing with federal agencies, then it is presumed that you would have knowledge of the authority of those agencies in which you're dealing with. Laws establishing legal relations, such as joint tenancy, the law of descent and wills, that the use of certain dangerous devices or products is subject to regulation. So I guess this is something where dangerous devices or products requiring regulation does make some sense. And the validity or invalidity of a divorce decree to which he is a party. It has sometimes been broadly stated that the presumption that all persons know the law is conclusive. Well, however, a better statement is that such presumption is rebuttable, varying in force with the facts, strong in the case of a lawyer, or with respect to general laws which are matters of common knowledge, and weak, almost non-existent, in respect to details or to laws which touch few persons. So there you go. The presumption is rebuttable, varying in force. So when you're talking about laws which touch few persons, it's almost non-existent. While a person is, for public reasons, held responsible for his conduct, although ignorant of the law, there is no conclusive presumption that he actually knows the law. Furthermore, while everyone is presumed to know the general laws of a state or country where he resides, everyone is not presumed to know the orders of local officials or regulations of administrative departments. There you go. However, all persons who contract with reference to a subject matter within the limits of a municipality as to which there are police regulations are charged with knowledge of and are presumed to know the provisions of the regulations, to have entered into such contracts with reference to them. Entered into such contracts. Police regulations, municipalities. Let's proceed here. It is presumed that a driver knows the law regarding the use of public highways. And this is Vigil versus Motor Vehicle Division of Department of Revenue in Colorado. So it is presumed that a driver knows the law regarding the use of public highways. What law could that be, though? Again, statutes and contractual obligations. Is there a contractual obligation with that motor vehicle department? That's how they can establish that. What was that? A conclusory? No, it was the presumption, the type of presumption we had here. Where did it go? Conclusive. The conclusive presumption. So by being in a contract, let's see where that one was here. Here we go. Effective court, the power of authority of federal agencies, laws establishing legal relations, law of descent, and certain use and the validity. But either way, there was a yes. And indeed, having for public reasons held responsible for conduct, although ignorant of the law, there is no conclusive presumption that he actually knows the law. However, they are expected to be responsible for your conduct. Let's see here. But the contractual things entered into contracts was key. Here we go. Yep. Presumed to know the provisions of the regulations and to have entered into such contracts with reference to them. All right, let's get over here to the chat. I think these are just case. Oh, wait, here we go. Here's our erection case here. Holding that one purchasing structures erected on government property by one operating under a lease of the property, which lease is void because not authorized by law, is presumed to know that no law authorized the making of the lease. Holding that all who deal with the government in respect of Treasury notes are presumed to know the exclusive authority of the Secretary of the Treasury to act for the government in retiring them. Wow. And let's see here, versus Calhoun Water Company and Jacksonville Public Service Corp. That's an interesting one there. Holding that one endorsing a promissory note is presumed to know the law governing his liability thereon. Wow, these are some pretty good cases here, huh? All right. The owner of land is chargeable with knowledge of general laws prescribing the manner in which it may be enjoyed or the title thereto affected. Wow. Knowledge of the general laws prescribing the manner in which it may be enjoyed. Well, I mean, it's pursuit of happiness here. And where would that limit that? What laws could limit that? The manner in which it may be enjoyed. Parties to a contract are charged with knowledge of the law existing at the time they enter into the contract and at the time it is to become operative. So both. There are changes in the law after it's been entered into, but before it becomes operative. Then when it becomes operative, it would have to have knowledge of that law. One contracting with a national bank for information as to the financial standing of persons is conclusively presumed to know that he acquires no rights thereby which may be enforced against the bank. Oh, okay. A party is presumed to know about the statute of frauds. That's a good one there. Knowledge on the part of the holder. So here's another banking one, it seems here, or a stock. Okay, here we go. Knowledge on the part of the holder of the invalidity of corporate stock. Its validity being a question of law must be presumed. Wow. Every creditor of a corporation must be presumed to understand the nature and incidence of such a body politic and to contract with reference to them. And to contract with reference to them. Nature and incidence of such a body politic and contract with reference to them. Interesting there too. Let's see here. Minerals. Holding that a quarantine. Now this is 1998, granted. Holding that a quarantine order prohibiting a person from going upon the street is not like a general law of which he will be presumed to have knowledge. Wow. Interesting stuff there. All right, let's check here with the chat. All right, it's working here. Boy, I got to catch up here. Welcome, Bill Thomas. When it comes to fire escapes, it is not safe to waive their erections lightly. Yeah, you definitely want to make sure you've proper erection when it comes to fire escapes. Yeah, Crystal, well, thank you. Hopefully more people are going to get the notifications. I've been on a little hiatus lately, but I've been haven't been on the screen, but I have been on the scene, so we're still working diligently here. Yeah, Bill, I've seen you out there and the rest of the YouTube land still enhancing your knowledge. Hey, we got power inherent in the people. This is the thing. Welcome. Definitely find some helpful stuff here regarding evidence. Let's continue. I think we're only on part 18. All right, here we are to chapter 10, the identity of names of persons, and starting with section 285 generally. It is generally held that identity of names gives rise to a presumption of identity of persons, or is prima facie evidence of it. So let me just break down here a little something here. Whenever we see generally, although on these headings here, this is appropriate, but when we say it is generally held is a little bit different than our heading for this section. This is a presumption. All these lees are presumptions. The generallys, the mostlies. These are presumptive language. In our mentioning presumptions with presumption language. So let's follow this. It is generally held that identity of names gives rise to a presumption of identity of persons, or is prima facie evidence of it. Identity of names. Interesting. At best, however, the presumption of identity of person from identity of name is ordinarily deemed to be an inference of a slight and inconclusive character. It is a weak presumption, which may be shaken by the very slightest proof of facts or showing of circumstances, which produces a doubt of identity. See this here? In the name. What's in the name? It has been held that the fact that there are many persons of the same name does not defeat the presumption of identity of person from arising from identity of name, although there is other authority to the effect that the presumption will not arise where the name is a very common one. It has also been said that if any circumstance appears to cast a reasonable doubt upon the identity of the person upon which a matter depends, a mere similarity of names will not suffice to establish such presumption. So again, we see here that generally, identity of names gives rise to a very weak presumption, which may be shaken by the very slightest proof of fact showing of circumstances which produces a doubt of the identity. All it takes is a shred of doubt that that name is not the identity, the person from the name. All it takes is the very slightest proof of a fact or showing of a circumstance to produce a doubt. So this is a very nice little section here, brief, to the point. And let's see here. This is interesting here, the types of cases here for it. Of course, there's names, Rupert versus Penner, Zingo versus Board of Liquor Control. I sometimes wonder if some of these case precedents are selected because of the names. Some of these names, Eli versus Gamble, they're almost like puns in themselves. It's just way too frequent to be simple coincidence, I believe. But I digress. All right, before we go to section 286, let's jump over here to the chat. All right, we got Craig Carey here. Yes, indeed, he's been watching the power inherent in the people, as we all have. And Jack Herrera. Wow, impressive. Very impressive. It's an honor to have you here. Name in chain of title. The rule that a presumption of identity of persons arises from identity of names, or, as is often stated, that identity from name is presumptive or prima facie evidence of identity of person, is often applied in tracing titles to real property. Thus, if the same name appears successively in a chain of title as a grantee or grantor, the presumption is that it was the same person in each case. Or, as it is often said, such identity of names is prima facie evidence of identity of person. The fact that the residence of the person is not the same in the two instruments does not alter the rule. If the name appears as a witness to the execution of a deed and to the certificate of acknowledgment as the officer taking it, it may be presumed in support of the certificate that the names represent the same person. So, witness to the execution of the deed, acknowledgement as the officer taking it may be presumed. So, okay. Let's see here. The fact that the grantee is of a certain city and the grantor 20 years later is of a county in another state across a river from such city does not interfere with the conclusion of the identity. What if they're past the county line and past the county river? All right, on to section 287. In criminal cases. In a criminal prosecution where the name is not a common one, and there is nothing to indicate that more than one person in the vicinity was known by the same name, proof of the identity of names is sufficient to warrant the conclusion of identity of persons. Unless the contrary appears, again, that slightest shred of doubt is all it takes, that one proof of fact to the contrary. The rule has been held to be otherwise where the name is a common one, and there are several persons who are known by it and are all located in the same place. Identity can be presumed from the name and other circumstances, and there is some authority to the effect that identity of names alone, without other circumstances, gives rise to a rebuttable presumption of identity of persons. Again, the name alone, with no other circumstances or facts, is shaky at best because it just takes one proof of fact of circumstance otherwise to put that doubt in there and then destroy that presumption as the evidence showing the identity of a habitual offender. Okay, well, we're going to digress a bit from here into the criminal section, but let's get to section 11 here. This is a good one here, to chapter 11, possession, ownership, and value of property. Starting with section 288, the possession and ownership of property, real property. It is a general rule that the fact that a person is in the possession of real property, exercising rights of ownership, and performing acts of dominion, creates a rebuttable presumption that he is invested with some right or title to it, which, where the possession was peaceably acquired, is lawful. Possession of land is always presumed to be in subservience to the title of the true owner, and is also presumed that possession continues under the same right by which it was originally taken. Where one enters into possession of land under a deed, it is presumed that he claims only that title given him by his deed, and that his possession is restricted to the premises granted. Granted where? Under that deed. Unimproved and unoccupied land is deemed to be in the possession of the holder of the legal title. So again, possession of land is always presumed to be in subservience to the title of the true owner, and is also presumed that possession continues under the same right by which it was originally taken. So, again, when one enters into possession of land under a deed, it is presumed that he claims only that title given him by his deed, and his possession is restricted to the premises granted in that deed. Whenever one claims property as owner and exercises acts of ownership over it, unquestioned and without objections by those most deeply interested, until the statute of limitations has run, the presumption is that his title is correctly stated by him. So that could be considered a color of title until it ripens under the statute of limitations has run out. A party will be presumed to have an interest in land that he can sell or assign, where at the time of the contract of sale he is in possession and cultivating the premises, and afterwards acquires a complete legal title. Long continued possession and use of real property create a presumption of lawful origin. Ownership and possession being shown of a building located upon the land of another, it will not be presumed that the building was located without authority. Of course. All right, beautiful section here. Let's jump over here to the chat and see if we have anything else. Oh, yes, indeed. Here we go. We are cooking here. Bill Thomas says, when we have silly sounding names in U.S. Congress, it makes me wonder if reality is making fun of us. Yeah, John Hickenlooper and Dusty Johnson, French Hill, Wiley. Yeah, there's been quite a few. Congress table. All right, let's continue on here. We're on to section 289, personal property. As a general rule, proof of the possession of personal property is prima facie evidence of the title or is said to raise a presumption of ownership, which may be rebutted or overcome by evidence of ownership in another or by evidence of the circumstances surrounding possession. Statutory provisions, creating a disputable presumption that things in possession of a person are owned by him, but are declarations of the general common law rule. But a rebuttable presumption that contraband found in a house belongs to the husband by virtue of his statutory status as head of the household is unconstitutional. That's interesting there. When a question of a party's possession and control of personal property or its use is an issue, proof of his ownership at the time in question implies that it was in his possession or that he had the right of possession and control. So again, proof of ownership at the time in question, right? That's what's the most important aspect here. In an action of trespass, okay. Well, now we need to go over to Black's Law and find out exactly what this one is here. I'm not going to pretend like I know it. Or are you able to pronounce that Latin there? So, hang on a second. That was... highlight this here so we see it. Trespass de bonus asportatis. Wow, all right. Let's find it. That's in the T, so it's going to be way down here. Bear with me, this is a scanned version of Black's Law. Political correctness, only 1979, huh? Interesting. We'll always have some serendipitous discoveries along the way, so just please bear with me as we get to the T's. It'll start to catch up once we go. Self-defense, 1651, huh? All right. Social contract, that's nice. All right, here we go. Stocks, we're getting there. All right. But it's TR, so it's way down here. All right, so trust is past trespass. I think we're on trust here. Trust, yes, indeed. Here we go. All right, so we have trespass, an unlawful act committed against the person or property of another, especially wrongful entry on another's real property. A common law legal action for injuries resulting from an unlawful act of this kind. Now, let's, oh boy. I think this is an important read here, but let me make sure they're going to have this here. Trespass, de bonus asportatis. De bonus. See if that's here. There it is. All right, let's read this one first, and then we're going to get back to that little inset paragraph there about trespass in general. Trespass, de bonus aspertatis. De bonus aspertatis. Trespass de bonus aspertatis. Aspertatis. Latin for trespass, for carrying goods away. A wrongful taking of chattels. This type of trespassory taking was also an element of common law larceny. At common law, an action to recover damages for the wrongful taking of chattels. This is a great one here. And this is from where? Doesn't say how long ago this was. Huh. I didn't see a date on this one. But either way, this is an interesting one here. A wrongful taking of chattels is removable property. And this type of trespassory taking was also an element of common law larceny. And at common law, an action to recover damages for the wrongful taking of chattels. So this would be the action to recover damages. If you were without the use of your chattels, then you could have a monetary value for that loss. Then you would be the action would be a trespass de bonus aspertatis. De bonus aspertatis. Okay. And I wanted to read this one here because this looked very interesting here, just under trespass, 13th century. But here we have this little from the textbook of Law Tort, 1950, the familiar legend on notice boards, trespassers will be prosecuted, implies that it is a crime. But this may usually be dismissed as a wooden lie. Yet in time past, the idea was correct. For trespass of any sort was punishable by fine and imprisonment, as well as redressable by an action for damages. And actually, it was not until 1694 that the punitive element disappeared, although it had faded into obsolescence long before that date. But nowadays, trespass is never criminal, except under special statutes which make it punishable. Criminal. Trespass is never criminal. The term trespass has been used by lawyers and laymen in three senses of varying degrees of its generality. 1. In its widest and original signification, it includes any wrongful act, any infringement or transgressions on the rule of right. Wow. Let's zoom in here a little bit more. The use is common in the authorized version of the Bible and was presumably familiar when that version was first published. But it never obtained recognition in the technical language of the law. It is now archaic, even in popular speech. So, that's interesting there. And 1, it was any wrongful act, an infringement, or transgression of the rule of right. That's what trespass used to mean. Forgive us for our trespasses and for those who trespass against us. That's where that comes from. Familiar with that version in the authorized version of the Bible. But it never obtained recognition in the technical language of the law. It is now archaic, even in popular speech. So we don't use it in popular speech anymore. And I believe even in the clergy, it's mostly been deprecated. All right, here's number 2 for trespass, the term. Remember, we're talking about the term. This isn't a definition. We're speaking about legal terminology. So second use of the term, not definition, in a second and narrower signification. Its true legal sense. The term means any legal wrong for which the appropriate remedy was a writ of trespass, viz., any direct and forcible injury to person, land, or chattels. 3. The third and narrowest meaning of the term is that in which, in accordance with popular speech, is limited to one particular kind of trespass in the second sense, viz., the tort of trespass to land. And that's the one we're mostly familiar with. Let's see if this continues. Oh, yes. Before the word misdemeanor became well established, the old writers tended to use the word trespass to indicate an offense below the grade of felony. And it was used at times by Blackstone for this purpose, as in the phrase treason, felony, or trespass. So it's referring more to misdemeanor than the trespass that we are normally use in our vernacular. So that's been a nice little digression there. And that means it's time to get back to law of evidence. So now we know what a trespass de bonis aspertatis is. In an action of trespass de bonis aspertatis, the ownership of the property need not be alleged or proved. Possession is sufficient because it is prima facie evidence of some sort of rightful ownership or title. So just by you having something when someone takes it, that's the trespass de bonis aspertatis. Possession of a certificate with power of attorney from the stockholder authorizing the holder to transfer the stock is prima facie evidence that he is at least the equitable owner. Where one is in possession of a house or land in which he occupies and over which he manifests an intention of exercising a control and preventing unauthorized interference, and something is found in the house or on that land by a stranger or a servant, the presumption is that the possession of the article found is in the owner of the locus in quo. Finders keepers in your house. As to presumption of ownership of negotiable paper, bills and notes. Wow, this might be an interesting read too. Where the source of title to personality is a will, possession raises no presumption as to the extent of the interest. Different results. Okay, as the application of this rule in cases, the identity of a person driving a motor vehicle at the time of an accident. Well, I'll be in a different AmJur. And we're on to section 290, the value of property. As a general rule, there is no presumption as to the value of property, other than the presumption sometimes indulged that value once shown may be presumed to continue in the absence of proof to the contrary. Proof of value is generally required whenever value is an issue, and it will not be presumed that the value of property is what it cost at an earlier date. It will not be presumed. So here's a supplement here, a case authority. In trial on amount of compensation for land allegedly taken or damaged in construction of state highway, it was error for court to allow evidence of comparable sales that took place after taking. Oh man, comparable sales, pretty weak evidence to start with, but then they do it after taking. Oh gosh. All right, well that takes us to the end of chapter 11. And we'll continue next time with a continuance of condition or state of facts. Now that we understand the basis of the knowledge of facts and how they apply in so many different situations, we also get some little bit of historical context as well for some very interesting words. So let's go here back to the chat. Let's see what we got here. Bill Thomas says he always enjoys the deep dives into the definitions. Well, I'm glad you do. I definitely do. It's one of the favorite parts about doing this is because it opens up so much more knowledge to the text itself. Just one simple word unlocks the rest of the information that's to follow. Indeed. Well, thank you there. Craig Harry says, I was trying to read quasi-tort. I'll have to rewind that later. I didn't see quasi-tort, but there was some, that was from a book about tort that we were reading about trespass. Yeah, like the replevin is a statutory remedy, I believe, as opposed to the trespass de bonis aspertatis. Bingo and bango and bongo or treason. We'll definitely be binging and bonging, and winner is definitely the Jack Herrera. Well, Bill Thomas, thank you for attending and keeping the stream going here with always a stimulating input. And we'll continue erecting more laws of the evidence as we continue down this very extensive volume of American jurisprudence. But I've kind of jumped over some of the more, the drudgery parts and the parts that might be a little bit risque, involving things that we can't really talk about here in the YouTube lands, but are more towards the the deviant and the criminal sides that most of us hopefully will never have to experience. And that being said, there still is a wealth of information here yet to be untapped. So please stick along. Hopefully, the notifications continue to get out, and we'll continue down the law of evidence. Thank you all for coming, and we'll see you on the next one. Peace out.